Take a seat.
Arbitration.
Hot topic.
Also known as alternative dispute resolution. Well known to you, quarter 5, quarter 8 as we speak. So this is just the same topic. I repeat, this is about the same you are studying in Skills 8, Skills 5. So there's no sort of special version of arbitration for a development project or for personal injuries or for whatever form of arbitration. It is positioned as not being governmental adjudication. In this hope, in this attempt of lawyers, legal professionals, to make a distinction between public and private. Because we need those certainties in life. And we like the whole idea that public and private is not the same. But I want to stress, and at the threshold of year 3, I think you can absorb this, that obviously it is the state that allows arbitration to mean something. So if a state, a sovereign state says, no arbitration in my country, then there's no arbitration. And so please remember that public and private is, as long as the legislator doesn't change the mind. 2, where it comes to international investment dispute settlement, the center that is in Washington, part of the Bretton Woods institution, is sort of owned and established by states. But that doesn't make it a state adjudication mechanism. Because a state adjudication measure means that you have a civil servant with the job description judge, who's paid with tax money to adjudicate dispute. And here, yes, the International Center for Settlement for Investment Disputes in Washington is sort of established by state, but the functioning of it is as a regular arbitration institute, being that the parties pay the arbiter, not the state. The goal is the ex post dispute settlement via a judgment, or in the arbitral world it's called a award. But at birthday parties they call it a judgment also. And so don't worry about those words. It's the fourth legal competence, legal regulation, that you bring a legal story to an end, binding for the two parties. 3 aspects. 1, it is based on the party choice. So the parties agree to accept this mechanism as the dispute settlement mechanism. If parties do not agree to alternative dispute resolution, no alternative dispute resolution takes place. Rule number 1. Rule number 2, how it is organized, how it looks like, is determined by the clauses in the contract. And thirdly, also the law that should be applied by the arbiters is determined, if you're lucky, by the contract. Or by the case law of such a exit institution, where previous awards determine, in the situation of a state versus an investor, where a bilateral investment treaty is applicable, the law we apply is, and then they have a book, a doctrine, and that they apply. The phrase of an alternative to applicable law is ex aequo e bono. to decide as reasonable and equitable men and women. So then you are not looking to a applicable law as in Article ABC of a BIT, Bilateral Investment Treaty, or Article this and that of a local law, but you are looking at the issue between the hairs of your eye, and you say, okay, it's sort of reasonable that you do this and you do that. And parties can agree in their contract that arbiters should decide ex aequo et bono. Aequo is sort of the Latin for equality, and bono is best or beneficial, so that's beneficial for both parties. And then the arbiter can say, well, you did stupid things and you did stupid things, let's cut the paycheck. You pay half, you pay half. Ex aequo et bono. Parties can agree to that. That saves a lot of legal memos of your side, where you have to analyze all the R's to then apply to the I. The mechanism is as every other litigation. So it starts with a claim, so a procedure initiating document, which sort of email or letter, Your Excellency, 9 out of 10 cases is about the investor suing the host state, because it's quite often the host state that infringes on the interest of the investor. Expropriation, new taxes. Oh, as of next Monday you have to pay 90% tax. Oops. Wrongful litigation, like local dispute of a laborer, and the company loses that case because the judge is the cousin of the ex-laborer. And you say, well, but he stole company profit. No, but in our legal system that's, unreasonable adjudication locally. And thirdly, the third way how a host state can frustrate an investor is the executive branch, like the police, who at the border says, I think today you're not coming in after a little vacation. But there's my plant. I need to manage because it's a foreign direct investment with the characteristic management involvement, long-term, money invested. And then the executive branch, including border police and so forth, can say, not today. Or the garbage company, state companies not picking up the garbage as a sort of retaliation of whatever the investor did. The claim is a letter to the Arbitration Institute and the opposing party, 9 out of 10 the host state, and that is sort of letter, letterhead of the law firm that is hired by the investor. And if it is to the state, this is Dear Excellency, comma, capital E, with this diplomatic language. My client, Chevron Incorporated, has the honor to inform you about the fact that according to our opinion, problems are arising out of the contract that we honestly entered into at date blah 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 blah, and herewith I invite you to take step 3 of Article 7 of the Rules of Procedures of the ICSID, and I'm looking forward to your polite response. These types of language. And they're much better. Mr. Worster is an expert in these types of letters because he made them as part of his career. And then you have to substantiate your claim. So you have to write a court document saying this happens, evidence, Iraq. Conclusion, host state should pay 2 billion. Step 2, defense. Legal memo, court document. All the facts are lies because the evidence is exactly 180 degrees the other way around. Conclusion, we do not owe anything. Comma, counterclaims. By the way, the investor owes us this tax, this royalty, that's performance, ownership of the company, and so forth. So, as an opposing party, you can file a counterclaim, which is sort of new procedure to which the original claimant can respond with a response in the counterclaim. So then you have two claims and two counter, or the two defense. And then somewhere in New York or Geneva or Amsterdam or London, they hire in a conference center a little room, and then parties meet. You know, funny thing is, those rooms are always extremely non-sexy, with very low ceilings. You know, that you think, I'm going to the house doctor or something like that. The multi-billion cases then discussed. You know, little door, coffee, all sort of. So I like state adjudication, because then you have a sort of courthouse, you know, with pillars and gowns and terrible coffee, and so arbitration is sort of low end in terms of look and feel. But the other way around, the arbiters are getting 10 times more than a local judge. An hearing and then a judge. And then arbitral awards are recognized in 170 of all the states of the globe based on the Arbitral Award Recognition Treaty of New York 1958. So there's a binding sort of thingy in the local economy. So Chevron then can go to Chad and enforce a judgment on the bank account of Chad if they do not pay. Here we have the exit with all kinds of floors, and this is the Tanzania case. And Gary Bourne is an attorney so much for lecturing in Leiden. So Gary Bourne is an attorney, I believe, from Paris. Toby Landau is a Washington attorney, and Bernard Hanotsiao is a Brussels-based attorney at law. So they are senior partners of firms. They specialize in arbitration. So they make $2 million a year as a partner of a firm, and then they are on the list of the ICSID, because an arbitration institute is a Rolodex institute. So it's a secretariat and a coffee corner and nothing. And then when there is a case, they appoint in a communication arbiter, and only then they are active. And then they bill by the hour. So they bill another $500,000 to read the claim, to listen to the defense, to listen to the parties in this sort of lousy room, write a judgment, do a few phone calls, and then next. So arbitration is a beautiful activity, meaningful for the parties, fun for the arbiters, and their 20 interns, they are not paying that much, but it's interesting to do. So that you see a building and sort of the faces what international arbitration is about. So ordinary guys who are taking the tram here, private people who are paid by the litigants. So Chad and Chevron or State of Tanzania and this German sewage company who was kicked out. And then sometimes they do not have a case in a year, and sometimes they have 3 cases at the same time. And so there's a market. Please pay attention, the treaty establishing the whole thing, and the center. So the center is the building and the name list, so the address list with people like Gary, Toby, and Bernard, who play golf once in a while, are nice. And the convention being the treaty that establishes it in the Tanzania case in your law collection is about Dar es Salaam in Tanzania. With a nice area picture. Parties, the sewage company of the municipality. So it's not always the central state, but quite often sort of the municipality. And the municipality enters into a contract with a local new establishment, operating company, of which the shares are owned by a French-German engineering company. And the obligation is to renovate and recreate the sewage system in Dar es Salaam. I believe 3.6 million inhabitants, and as we speak, or 10 years ago, no sewage system. So we talk about poop, ladies and gentlemen, and that stinks, and that hampers development. So step one in sort of development is that the poop is in a pipe and then processed, all right? And then the other topic is fresh water. And fresh water is sort of a fundamental right, which should not necessarily be too expensive. And then they got a dispute because the company needed to make the tap water more expensive to make it a viable project, to avoid to go bankrupt. And then the municipality said, well, but this we did not agree on, that you raised the price that high, so we kick you out, including the trick on the board. So this engineer who was running, you know, the whole project was sort of not accepted at the border and put on a plane back home. And then they expropriated all the belongings and they say, we don't want to see you anymore. And then the company sued Tanzania, and there was a sort of award, and in the workshop lecture we will discuss it. Last but not least, the Egypt case. So far we discussed very clear development project, but it can also deal with services, like a Danish company getting the exploitation contract of this Cairo hotel. So the hotel is owned by the Project 7, the owner of the land, which doesn't play a role in the case. And then the contract, the investment contract was, okay, Danish firm, you may renovate the hotel and then exploit the hotel exploitation contract for 20 years. As long as you have 5 stars. And then the Egyptian hotel star ranking inspectorate passed by this hotel and said, I think you're a 4-star hotel.
Yeah.
And then the investment contract was terminated, and the hotel manager was on the border, on the airport, put in a plane back home after they renovated the hotel. And then the Danish company sued Egypt for this behavior, and for the workshop lecture please read the outcome. So that you see that it can also be about services rather than sewage pipes and water pipes. So in the case, I believe the name of the hotel was different, so this is a more recent picture of the hotel. Took me half a day to find it, because I needed to check the address in the contract, and then through Google Earth, check which building is there, and then through Google Earth I had to go back to Instagram to see a picture like this. That is what I do as a lecturer. Thank you for your attention. See you next week in the workshop lecture.